Your latest Murgitroyd webinar will start in a few moments. For more information on today's panel and our company, visit murgitroyd.com/webinars.
Hello and welcome to the 8th series of Murgitroyd online seminars. We are delighted to reconnect with our regular listeners and a warm welcome to those of you tuning in for the first time. Our webinars are here to keep us all up to date on the latest developments in the world of IP. Please don't forget you can submit questions via email at webinar@murgitroyd.com. You can also contact us by Twitter using hashtag Murgitroyd Webinars. And remember to tag us at Murgitroyd. So, let's go straight into today's webinar.
Hi, I'm Cath Coombes. I'm a Director of Patents at Murgitroyd and I'm based in the York office. And I'm delighted today to be joined by my colleague Tom. Dr. Thomas Gibb is a Director of Patents at the Southampton office and he also heads our professional practice group here at Murgitroyd. Hi, Tom.
Hi, Cath.
So we're going to be talking today, Tom, about some of the updates that we've been having at the EPO. Now, I know some of them are based on the pandemic and some of them are being brought in view of the new changes to guidelines, which is coming in on the 1st of March, I believe. Can you tell me about some of the changes?
Yeah, so the changes are coming in on the 1st of March this year. And I think the first thing it's important to say is this is the first update to the guidelines since November 2019 as part of the EPO strategic plan and to get more engagement from the people who use the EPO, applicants and attorneys. They changed the procedure of updating them from November each year to the beginning of March. So this is actually the first update for quite a long time.
So what are the main changes that are being brought in, Tom?
So I think the main change that everyone's talking about is the changes in what happens to the description of a European patent application when it's close to grant. So in the new guidelines, there was quite a lot about amendments to description, and these really formalise an internal practice note sent to EPO examiners towards the end of last year in view of recent case law. So the key takeaway is that the examiners at the European Patent Office are going to get far stricter on what they're allowed to stay in the description after the claims have been amended during examination. So now the description will have to be amended so that any subject matter that remains in the description that is outside the scope of the claims is clearly marked as not part of the invention, or alternatively, is deleted from the application entirely.
So do you see this as a big practice change?
I think it's something that all applicants need to be very careful with. I think some examiners have been applying this. As I said, this comes from case law that's been around for a little while. Some examiners have been applying it quite strictly already. Others haven't, but this formalises it. So there should be a more uniform approach across all examiners. I think the key thing for applicants to consider is that these amendments to description don't unduly limit the protection you get from your claims in any potential future infringement proceedings. Lots of countries around Europe, including the UK, have a doctrine of equivalence or so similar, whereby subject matter that's not literally within the scope of the claims can be considered to be within the scope of the claims if it is equivalent to the subject matter claims. Without going into the details in too much depth, basically deleting things from the description or suggesting it's not part of the invention could reduce the scope of what is seen as equivalent later in litigation. This is obviously something that applicants don't want to do.
And I believe there's some other changes in the guidelines as well. Can you tell me about some of the other changes?
Yeah, so I think the guidelines have also been used, or this update has been used, to really continue the EPO's continued march towards video conference oral proceedings as far as possible. For those who are less familiar with the EPO proceedings, oral proceedings happen sometimes at the end of examination to reach agreement on claims that can be allowed by the Patent Office as a patent, and potentially more commonly at the end of opposition proceedings when the validity of a granted patent is in dispute. Obviously, due to the COVID-19 pandemic, proceedings, holding them in person in Munich or The Hague, has been nigh on impossible for the last 12 months. So to prevent the backlog building up even further than it has already, the EPO are moving towards holding proceedings by video conference. Over the last year, the EPO have made a lot of changes to bring this in, changing the regulations and the rules. And the guidelines here are mainly just to formalise some of the more minor points regarding how procedures should be followed and how parties should be summoned to proceedings and precisely what is expected of them at proceedings. I think one of the biggest changes, though, in this area is that previously, if you had failed video conference oral proceedings, you would then, for example, with a technical issue, you would then likely be summoned to in-person proceedings at a later date. However, the guidelines have changed that so that if you have failed video conference proceedings, your next summons will also be to video conference proceedings. So in other words, the proceedings will stay virtual.
Mm-hmm. I mean, this has been a big change that has come in, hasn't it? Initially, it was, at least for opposition, both parties had to agree to video conference. And that has now changed, hasn't it? And it's become almost mandatory to do it by video conference unless you've got very serious reasons not to do so.
So in examination, it looks like video conference proceedings are very much here to stay. The guidelines are now updated to say that you need, as you said, serious reasons to hold them in person. And serious reasons are given examples. For example, if any party to proceedings has an impairment, such as a visual impairment, that means virtual proceedings are simply untenable or can't be carried out, or whereas a kind of the feel of the item in question is key to making a determination about its patentability. So it really is very, very limited circumstances. Blanket suggestions that oral proceedings by video conference are not suitable and just will not be accepted by the EPO. Serious reasons truly does mean very serious reasons.
I mean, I noticed in one of the CRISPR oppositions that are ongoing, so huge multi-party oppositions, 492 cited documents, complexities because it's a new field, and also lots of different locations of parties. All of that was put together by both patentee and several of the opponents. And still, the EPO had refused an in-person oral proceedings or to delay the oral proceedings until such time as it could be held in person. So that just kind of emphasises that it's not, purely for complex cases. It really is a very narrow subset now.
Certainly. I mean, these new guidelines have all kinds of information about what to do. So for all the 3 opposition division members, what they should do if they're in separate locations, for translation, things like that. So these guidelines really do update all those kind of, more complicated opposition matters and proceedings and how to deal with them. So as I said, we really are looking at the most serious reasons now to not hold video conference proceedings in examination or opposition.
And I noticed that there's been a whole section added about the patenting of antibody applications into the guidelines now. And I think it's quite welcome, isn't it, to have some concrete information there in the guidelines. But from my review, it seems to be that it's basically putting down in writing what is generally happening in practice.
I think that's my understanding too. It's kind of to really clarify the situation for applicants and parties in this area, as you say, because there wasn't much in the guidelines before to help examiners or the applicants ensure certainty. So I think it's a really useful step forward.
And talking about other changes that we've seen at the EPO then in view of the pandemic, obviously the video conferencing being brought in was one of those. Have you seen in practice other changes resulting from the pandemic?
So obviously at the beginning there was a lot of leniency regarding deadlines, but that period is now past and the EPO is enforcing deadlines in its usual stringent manner. In terms of other changes, I think there's a recognition of the EPO that this pandemic has the potential to cause quite a significant backlog. And that is against, as we all know, early certainty and other processes implemented by the EPO to try and speed up the granting of patents and the opposition and appeal procedure. So I think the EPO has generally, with the examiners, has taken quite a pragmatic approach here and has really used the advantage of some of the things that they're bringing in with the ease of video conference or proceedings now compared to everyone going to meeting, is to making that potentially summonsing earlier on in the examination process. So speeding up examination and trying to get a decision about the grant or refusal of a patent application at a much earlier stage rather than letting proceedings drag on as they might have done before.
So the early certainty you were on about, these were the targets that were set by the EPO, so that by 2020, from start of examination to a conclusion, a median case would be 12 months. And obviously, I'm sure the pandemic has hit that quite significantly, hasn't it? I mean, I've personally seen a huge uptake in number of calls to oral proceedings at a very early stage, usually after just the first examination report these days, I would say.
Yeah, I mean, very much a drive to get things done quickly. And so I say certainty for everyone. So the patentee or the applicant knows what they're right, and for third parties to know if a patent will be granted. And I think that's a welcome step forward.
And so do you have any practical tips then for applicants in view of these changes that you're seeing?
Well, I think the key thing is that to be as responsive as possible with the EPO, if they issue you examination report, I really would encourage, responding as soon as possible. Obviously, take time to consider your response, but once you know how you want to proceed, I would really say put that on file kind of as soon as possible and work with your attorney to make sure that happens. Because obviously, the quicker you respond, the quicker you'll get something back from the EPO, and you're helping them achieve their aim of getting these cases kind of finished and decided in short order, efficiently. And so by responding to them more quickly, you're not running down the clock. You might get further communications from them when previously you just get a summons to proceedings. And I think just working with the examiners by responding quickly and promptly, and if they, as they are doing more frequently now, phone you up as a representative, I think just respond efficiently to that and really help them move the process through so everyone can get some certainty at the end of the proceedings.
Yeah, I definitely echo that. I guess with all of these increases in oral proceedings that we're seeing, again, when we get those, engaging with the examiner early, not waiting for the deadline to file our final submissions prior to an oral hearing, but engaging early with the examiner and working with them can be really beneficial to avoid the need for these oral proceedings.
I certainly agree with that. I think whenever you get summons to oral proceedings, responding as soon as possible, because so often you get further communication, either narrowing down the issues to discuss at oral proceedings, because the examiners, you've overcome some points raised by the examiner, or just issuing a 7213. And it really does help things out. The summons to oral proceedings does not mean that an oral proceedings is inevitable. If you respond to the examiner in good time before that date, especially now as those dates are quite often away in the future, it gives you a chance for some discussion with the examiner to really focus your application and potentially avoid the cost of those proceedings.
Yeah, and I guess we've got also tools available to us now, haven't we, to understand the examiners more, how likely they are to bring you to oral proceedings at an early stage, rates of success in getting patents granted despite being called to oral proceedings, which we can use to inform our decisions about how to proceed.
Certainly, I think that data-driven approach is something we've really embraced here. And I think it's a great way of ensuring that clients get good value for money for their applications, and their applications are progressed in a way that ensures they move forward cost effectively.
And some other changes. I believe there's some changes to Unity that have been brought in.
Yes, there are some changes to Unity, although I think practically day-to-day applicants will see very little difference. So the changes to Unity is based from a harmonisation project between the European Patent Office and the national patent offices of the countries within the umbrella of the EPCs, like Germany, UK, Switzerland, for example. And the idea is really to have like kind of a consistent reasoning behind the Unity decisions. So while the approach isn't changing, what you are likely to see more is a more detailed explanation from examiners saying why they have raised a Unity objection. The guidelines now have a minimum set of standards which the examiner must meet when explaining why they have raised a Unity objection to an application. So applicants should be far clearer about the reasons for the objection and potentially how to overcome it.
That's definitely a welcome change. The more reasoning you have, the more you can objectively determine whether actually that's reasonable or not. So that's great.
I think there's obviously a few more minor changes in the guidance. I think one of the more interesting ones that has gone under the radar slightly is, as I mentioned before, examiners seemingly increasingly phoning representatives if there are very minor issues to discuss at the end of proceedings, so potentially some small formal matters in the claims or regarding the amendments of the description before grant. And previously this was done by telephone usually. And these guidelines are updated to suggest that instead of telephone calls, these kind of discussions should be undertaken in a conference, so i.e. a video call, much like this one. To date, I haven't seen this happen, although obviously the guidelines haven't come into effect. But I do wonder if there will be a change away from the telephone, because it is very convenient. And I have to say, a lot of cases clear the final hurdles with a couple of quick calls.
And telephone's really convenient. You can pick the phone up to anybody anytime, but the video conferencing, you need to arrange a time and a meeting beforehand. So for me, having a call with the examiner on hand's a more straightforward format, I think.
Agree with that. Although sometimes the objections they raise are a little bit more substantive. So it might be good to have a little bit of warning before they ring you up out of the blue to discuss the patentability of one of the claims.
Yeah, absolutely. And it is good to have more face-to-face contact with examiners. I think that is actually really helpful.
I certainly agree with that, because it's certainly make sure everyone's clear and everyone's understanding each other's position. Certainly sometimes when, it feels like examinations maybe stalled slightly, a conference is a great way of kind of moving that forward and really getting down to changes that need to be made by both parties to get this case moving towards acceptance and grant.
And one of the advantages as well is that even if your inventors or your applicant are in different countries, the ease now of getting them involved. And that's really helpful if you think that the main issue is to do with the understanding of the invention in itself. So I think that's definitely been a very welcome change.
Definitely. The ability to get inventors kind of in front of the examiner with these kind of things, especially with oral proceedings now, inventors are much more likely to be able to join by video conference than they are to be able to travel to physical in-person proceedings. It's just, I think that's a great advantage of the whole video conference scenario.
Well, thank you so much, Tom. That's been so helpful to discuss all of the different changes that are occurring. I've really appreciated it.
Yeah, it's been great. Thanks, Cath.
Bye-bye.
We've reached the end of today's presentation. To find out the topic of our next webinar and to register, visit murgitroyd.com/webinars. And whilst you're there, why not keep up to date with our latest content by subscribing to our mailing list? Thank you for your valuable time today and for all your questions. We hope you found the subject matter relevant and well explained. Should you have any other questions or wish to discuss the topic further, please contact us at webinar@murgitroyd.com or via Twitter @Murgitroyd. Until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our webinars are topical and informative. We are always looking for suggestions for new topics for discussion. So if there's an area of IP that you are keen to understand better, please drop us a line at webinar@murgitroyd.com.